Today we are looking at the relationship between the federal and state powers in the United States, and more particularly, the division of jurisdiction between the federal and state courts. But let's first take another quick look at the relation between the federal and state powers in the United States. After the 13 colonies won independence from England, they formally became states. So that they could work together successfully, the states formed a league pursuant to the Articles of Confederation signed between them. Under this agreement, the new states retained most of the power, and consequently the newly created national government was too weak to face the threats posed by other countries, in particular the United Kingdom. Thus, a new constitution was signed, and in place of a confederation, a federation of states was put in place. Under this new system, the powers of the federal government were reinforced at the expense of the powers of the states. Under this new relationship, the federal government was given power over areas such as printing money, declaring war, foreign relations, and foreign and interstate trade. The states retained authority over areas such as health and safety, overseas trade occurring within a state, education, and ratification of amendments to the US federal constitution. The federal and state governments agreed to share power in areas such as taxation, the adoption and enforcement of laws, and borrowing of money to finance expenditure. As we have seen, under the Supremacy Clause, federal law is supreme over state law, but federal law is meant to be restricted to its enumerated express powers. Thus, looking at the list of federal power in Part 5 of Chapter 5, one would think that the states and not the federal government would be responsible for issues such as same-sex marriage or marijuana consumption, but this certainly does not appear to be the case. For example, although the federal Supreme Court has ruled in favor of same-sex marriage at federal level, a married same-sex couple living in a state that does not recognize same-sex marriage will not be treated as a married couple as regards either state or federal tax law. The same couple living in a state that does recognize same-sex marriage will be treated as married for both state and federal taxes. Consequently, there is not a uniform application of federal law throughout the nation as regards the tax rights of same-sex couples in a same-sex marriage. In the same way, there are federal laws such as the Controlled Substances Act restricting the consumption of marijuana. Thus, even if a seller of marijuana is in one of the many US states that have legalized its consumption for medical reasons, for example, he or she can still be prosecuted under federal law. Further, marijuana growers legally producing under state law are at present being prosecuted under federal law. It seems that even after 200 years, the US is still trying to deal with the relationship between federal and state law. Now let's look more closely at the relationship between the federal and state courts. As we saw in our last presentation, there are in fact 51 separate jurisdictions in the United States, 50 separate state jurisdictions, and 1 federal jurisdiction. As a result, there are 51 sets of courts in the United States, 50 separate state court systems, and 1 federal court system. As most laws in the United States come from the states, with federal law only playing a limited role, most legal actions in the United States are brought before the state courts. So how is jurisdiction divided between the federal and state courts? If a matter involves state law, clearly the courts of the state concerned will have jurisdiction. In the same way, if a matter raises an issue under federal law, the jurisdiction of the federal courts will be triggered. If a matter concerns both state and federal law, for example murder, in theory the federal and state courts will both have jurisdiction. However, in such cases, normally the matter will be left to the competent state court unless it involves an issue of special federal interest. What happens if two different states can claim jurisdiction over an action that is being brought? In such cases, sometimes the Erie Doctrine will apply. What is the Erie Doctrine? Well, if more than one state is claiming jurisdiction in a civil matter arising under state law, then under the Erie Doctrine, the federal courts may take jurisdiction over the matter. According to the Erie Doctrine, federal jurisdiction is triggered when the parties are citizens of different states, are non-US citizens, and the amount in question is over $75,000. This is also referred to as the federal diversity jurisdiction, and the doctrine was developed to ensure fairness of treatment when a case is filed in one state involving parties from that state and parties from another state are non-US citizens. We hope you enjoyed this discussion of the relationship between federal and state powers and the federal and state courts.